Okay, let's begin lesson 3. Now, again, going back to a semester ago, um, I would begin a PowerPoint and I would begin to go over the most pertinent laws regarding human resources. And I would then ask whoever was assigned to the particular piece of legislation to weigh in and to basically use the PowerPoint slide and go from there. So what I'm going to try to do is I'm going to touch on each of these, but then just kind of count on when we do meet in a week that whoever is assigned which law will pick it up and take it a little bit farther than perhaps what I'm going to present here. All right. So the first one is not assigned to any of you. The first one I intended to take myself anyway, and that's going to be the Civil Rights Act of 1964. And then you'll see some familiar things here when we self-selected and opted for our assignments: the Age Discrimination, Americans with Disability, Fair Labor Standards Act, Equal Pay Act, Immigration Reform and Control Act, uh, OSHA, and PESH, New York State Employee Safety and Health, and then the Family Medical Leave Act. All right, so let's begin with the Civil Rights Act of 1964. And having completed this, I will post, as promised, topic paper number 1, the compare and contrast affirmative action, diversity, and managing an inclusive workforce. I try to get as much of the lesson that pertains to the topic paper in before I actually put the topic paper up as an assignment. So you will see that along with this lesson tomorrow, Thursday. Right? So Civil Rights Act of 1964 puts a specific date on a very long story. We can certainly go back historically and look at other pieces of legislation, other Supreme Court rulings that moved the ball forward in terms of civil rights. Famously, 1954, Brown versus the Board of Education, finding that separate is inherently not equal. Okay, and that led to the integration of public schools in the country. Um, the Civil Rights Act of 1964 spoke specifically, among many other things, spoke specifically to discrimination in employment uh, and Title VII. So we often talk about Title VII, created the Equal Employment Opportunity Commission to implement and enforce the law. Discrimination based on race, color, religion, sex, national origin, disability, or age in hiring, promoting, or firing. All right, there's a link here, and I will be mindful of posting the unnarrated PowerPoint so you can actually click on the link. I'll make sure I put both of them up tomorrow. Um, so regarding discrimination in employment, uh, there were certainly strides taken prior to 1964. Famously, some of the steps included Harry Truman integrating the armed forces in 19, I believe, 46 or 48. Um, President Kennedy, had an executive order that used for the first time the term affirmative action, that affirmative action shall be taken. And actually, I believe 1961, the executive order also established an Equal Employment Opportunity Committee that didn't have enforcement authority. Enforcement authority actually didn't come to EEOC until the early 1970s, 1972, when the Equal Employment Opportunity Commission Act was passed and gave the EEOC prosecutorial rights to take people to court who had complaints of discrimination brought against them. All right. So as I transition from one slide to the other, I realized I had an incomplete thought that I just left behind, and that was regarding the Kennedy executive order. So always be aware that whenever we talk about presidential executive orders, and there's been a lot of talk over the past several years about presidential executive orders, that they are very limited in scope. A president has administrative authority over the federal government and people doing business with the federal government, contractors. So when Kennedy talks about affirmative action shall be taken to achieve non-discrimination in employment, the executive order specifically referred to contractors with the federal government. Other executive orders came later, even after the Civil Rights Act of 1964, that had direct impact on federal government hiring, contracting with the federal government. But always remember that that's usually the scope of an executive order. So, and a little bit more, we always talk about Title VII Civil Rights Act, and that's always my focus. That's the focus of this course, Human Resources and Employment. But it was sweeping legislation, right? It was historic and sweeping legislation. I don't remember what titles go with what topics, but I'm pretty sure Title I was voting rights. There was non-discrimination of public accommodations, non-discrimination in public facilities. Ba, 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 ba. Then we got to Title VII. All right, I'll jump to Title VII. Title VII applied to private employers. So there you see that range. You see the range beyond an executive order. Now we're applying legislation to all hiring, regardless of what sector you're in. Okay, so when we talk about hiring and employment practices, you see it here: hiring, promotion, discipline, assignments, terms of employment. And the Equal Employment Opportunity Commission became the enforcer of non-discrimination, the place to file complaints, the clearinghouse for any number of issues after the legislation was passed. Now, I said earlier, interesting that the EEOC did not immediately have prosecutorial power. That didn't come until the early 1970s, when it could actually pursue and take employers to court. It could make rulings, it could impose fines, it could support individuals or class action suits against employers, but the EEOC itself was not able until 1972 to bring lawsuits against employers. Right? So the EEOC began to receive thousands of complaints from employees as soon from its inception. I don't know what you would expect if there's legislation regarding discrimination in employment. It is my understanding, and from my studies, it is that the EEOC started to receive something that it didn't necessarily expect, and that was many, many complaints regarding sexual harassment in the workplace. So I just showed you previously employment and promotional opportunity and work conditions, and I don't know if I think the expectation was that it would not automatically default to complaints regarding sexual harassment in the workplace, but it did. And that's where we get a lot of requirements for training and sexual harassment policies in workplaces, and a process to handle those complaints in the workplace. Just a word on disparate treatment and disparate impact. So disparate treatment is simply, how do I treat you? I'm the manager, I'm the owner of a business, the head of an organization, and I have an issue with an individual. And my behavior toward that individual may deny that person employment, promotion, the long list of employment practices, because I don't like that person, or I don't like the class that person comes from, the minority class that person comes from. It's personal. It's I don't like you. Okay? Disparate impact is beyond individual like or dislike. There's something systematic here. There's something about the way we do business that excludes members of minority groups, protected classes. Okay, I'm going to talk about that a little bit when we meet next week. What kind of practices might exclude? What kind of practices, just by the way things are structured within an organization, might cause discrimination in employment. So I want you to give that a little bit of thought. The question is going to be, how might that play out? What might be evidence of that in an organization? So think about that, and we're going to have that conversation when we meet in a week. So I mentioned the overwhelming number of sexual harassment complaints that the EEOC began receiving, and so it needed to further define, further support the issue of sexual harassment. I'm going to just do this briefly. I'm going to think that you all have had some sexual harassment training. I might ask you again, perhaps next week, tell me what kind you have, how frequently do you have it? So two types of sexual harassment: quid pro quo, which is Latin for this for that. That implies a certain amount of power that one individual has over another. So almost exclusively supervisor over subordinate. If you do something for me, I'll do something for you. So quid pro quo. It has actually, there have been a couple of court cases that have taken it beyond supervisor to subordinate, where a third party is part of a lawsuit who is not the supervisor or the subordinate, but is a third player, a third actor who is involved somehow in targeting an individual. Right? So more time goes by, more cases are brought, and we find nuances in case. But by and large, quid pro quo suggests power of one individual over another. The other type of sexual harassment is defined as hostile work environment. So that's not a one person directed at another. That is, I am uncomfortable in this work environment. So this is truly in the eye of the beholder. Doesn't have to be a principal, doesn't have to be a supervisor or a subordinate. This is, I am uncomfortable coming to work. I am unable to do my job because of the environment that we have established here. So in my earliest days at City Hall, I was in charge of the city's summer youth employment program, where we would have 550 kids working in offices and locations throughout city government. And this was in the 1980s, so forgive me if I'm going to bring up what I hope is a bygone era. The city doesn't have locker rooms, shower rooms. We do have something that we call ready rooms. And ready rooms are where people would come in and put their work boots on and get ready to go out in the field for a day. And you might guess that some employees would have pictures and posters hanging from lockers that were simply offensive. I mean, they were offensive to me back in the mid 1980s, and I certainly couldn't bring 16, 17, and 18-year-old young men and women into that kind of a work environment. So would have to go around and I have to ask people to clean up the place. I'm going to throw out a question to Dan. Danny, be ready to tell the group what man on the roof means in a Rochester Fire Department station. And that can be a little discussion we can have about work environment. Okay, a little bit repositioned here. I realized, now am I getting rid of that glare? Trying to get rid of the glare and the glass behind me. So a last word on Title VII, that retaliation against an employee for participating, for bringing a complaint, for participating in an investigation of a complaint are to be held harmless by management. That is, there can be no retaliation in terms of job security, job placement, job compensation for an individual who has brought a complaint. Right? And again, this has been kind of in the news all the way to the top over the past couple of years. But this is what the law states and what the courts have consistently upheld fairly successfully. And just a word on, if you want to take it up to Washington, the White House, there's that caveat again that a presidential administration kind of operates in a bubble, right? And sometimes the things that apply to the rest of us or to other sectors in employment don't always apply at the highest levels of government. In fact, some of you probably know this, right? That when Congress passes a law, whatever the law is, does not apply to the Congress that has brought and passed any piece of legislation. The reason for that is that any piece of legislation should not impact legislators voting on it positively or negatively. It needs to be neutral. Hence, any law that's passed doesn't apply to the sitting Congress. Um, and so, that's the system that we live in. And, there are inherent irregularities, inability to apply things equitably all the time, right? So I'm going to just run through these and you're going to see names up there. So Vilma and Barney, if he's here, has not yet been at any of our sessions, but I added his name to Vilma. So Age Discrimination Act is passed in 1967. And I will simply say that after the Civil Rights Act of 1964, which did include age, but it did not include any specifics. So, as often happens, several years later, we go back and we fix it. We put some parameters in, and we call it the Age Discrimination Act of 1967. And I will look for Vilma and whomever else to fill in some of the gaps. So, the Americans with Disabilities Act, 1990, there was a Rehabilitation Act of 1973, but like so many other things, it began with limited scope, limited to the federal government and programs and employment with the federal government. The 1990 legislation made it applicable to all employers of 15 or more employees. The key term here is make reasonable accommodations. All right, I will save a real city experience on making reasonable accommodations for when we meet. Part of my multifaceted career was being the city's first ADA officer when the legislation came through in 1990, and just a remarkable experience I had in finding out the wonders of technology and what can be done. Um, but again, focus on reasonable accommodation. What's reasonable for an organization? What kind of accommodation is being requested? Incumbent on the individual to make the request for accommodation, and then dependent on the size and resources of an organization as to what's reasonable or not reasonable. The Fair Labor Standards Act, 1938. This is one of the big ones. So Fair Labor Standards Act passed as the country was, I guess, still somewhat in the depths of the Great Depression and part of the Franklin Roosevelt New Deal package of legislation. Um, and the Fair Labor Standards Act established a first time ever minimum wage. It outlawed child labor with some exceptions, minimum wage with some exceptions, overtime pay, established a 40-hour work week, 8-hour workday, 40-hour work week with overtime pay included. So it was a real milestone. And every time the minimum wage is revised upward, presumably, um, the Fair Labor Standards Act is amended. Right? So it's very much still with us, a real living piece of legislation. Now, we often hear a lot of talk about minimum wage and the need to meet the minimum wage, and the Congress, the federal government, honestly hasn't led the way. I believe the last minimum wage hike was during the George W. Bush years, 2003 or 2004, and it hasn't budged since then. Um, yeah, and I think 10 years prior to that was the second most recent. So the federal government doesn't lead the way; it often stalls. So what can we do? Obviously, private business and industry can move ahead with their wages, their minimum wages. Um, but as far as governmental jurisdictions, there are two possibilities. So one possibility would be an executive order, right? And what have I said a couple of times already? That an executive order has a scope of the federal government. So um, in 2015, Executive Order 13658 established $10.10 as a government contractor minimum wage in 2015. Um, through follow-ups to that order, it's now, I believe, maybe an update to this, maybe it's $10.60 per hour. Minimum amount covered for tipped employees, $7.40 an hour. If anybody has an update on that, please let me know. So, and then the second recourse is that you will see states, you will see cities moving forward to impose minimum wage requirements within their jurisdictions. Okay, so in fact, New York State has a fairly aggressive minimum wage increase schedule and distinguishes the rest of the state from New York City. So executive orders can move things forward in the federal realm, and states, and in fact even cities imposing living wage requirements and businesses doing business within a certain city limit or county limits, um, is the way to move forward in the absence of federal leadership. The National Labor Relations Act, 1935, a major piece of legislation empowering bargaining units, representation for employees by unions to negotiate wages, benefits, and work conditions. 1935, still pretty much in the depths of the Great Depression. The Franklin Roosevelt New Deal to stimulate the economy and to empower workers. This was seen as, it says, as correcting an inequality of bargaining power. So the inequality between employer and employee is corrected by having employees be able to be represented, by a bargaining unit. Um, like everything else, there was a political split. What a surprise. There was a political split on this legislation. Democrats favored the employee right portions. Uh, the Republicans at the time opposed. And by 1947, another piece of legislation that I don't have listed separately here, but certainly worth mentioning. By 1947, the Senate has flipped to Republican hands, and Republicans are able to counter legislate with a bill called the Taft-Hartley Act, 1947. Taft-Hartley Act, 1947, rolls back some collective bargaining unit rights. It says that employees don't have to be represented, don't have to enter into a, a, a union in their employment. Throws some doubt into a bargaining unit's ability to collect fees from all its members, and doesn't require, it doesn't require that you become a bargaining unit member to be employed in a particular business or industry. So a pushback of some, not all, rights to bargain come just 12 years after the NLRA legislation. I should also say regarding the union fees, because this has just gone on and on for years and has been a major point of contention, that just a couple of years ago, Janus, Janus, versus AFSCME. AFSCME is the American Federation of City, County, and Municipal Employees. The city civilian union is AFSCME. And we have several others, police and fire and a few other small ones, but AFSCME is the city's major civilian union. And the Supreme Court ruled that, let me back that up a little bit. What unions had begun to do to enable them to continue to collect fees was to say, you don't have to be a member of the union, but you're still going to pay the fee. Now that may sound just on the surface unfair. If I don't want to be in a union, why should I have to pay a union fee? The unions counter that you may not be in a union, but when a bargaining unit uh, bargains, the results of the emerging contract with wages and benefits and work conditions applies to everybody. So you may want to sit it out and not be a part of the bargaining unit, but you're still going to get all the benefits. So you cannot be a member, but you're still going to pay the fee. What the Supreme Court decision of a couple of years ago, Janus versus AFSCME, did basically was say you can't collect a fee if an individual doesn't want to become a member of a union. And so that has been seen as a major blow to the power of union membership, because you could just sit it out. Because I was part of management with the city, I was actually never a union member. But those who were, are almost 3,000 other employees in some bargaining unit could just say, I'm not going to pay my union dues. I'm not going to pay my $20 a pay period or $40 a month or whatever the amount is of the fee, because I just don't want to give that money up. But you're still going to get the benefits. So a major blow 2 years ago to bargaining units. I'm going to hop over these next couple. I'm going to leave Melissa and Miriam to discuss the Equal Pay Act of 1963. All right. And a good number of attempts to correct pay inequity over the years, including the Lilly Ledbetter Fair Pay Act of 2009, which was a kind of a technical correction to when a lawsuit could be brought against an employer. There had been an 180-day statute of limitations that expired from that counted from the time the inequity began. It didn't count when the inequity was discovered. So you could say, I began this job, in 2015, and I didn't realize until I sat down with a colleague and we got to talking that there has been an inequity here. Well, your 180-day statute of limitations has expired because the clock started when you entered employment. So the Lilly Ledbetter Act just simply took that statute of limitations window away, made it 6 months. And yet, having said that, we're 50 years past the Equal Pay Act and we're still discussing issues of gender and race pay equity. So still an ongoing concern. The Immigration Control Act of 1986 required employers to find the citizen status of their employees to make sure that they were not knowingly hiring unauthorized immigrants. These things all have some very specific connection and put requirements on human resources to act on. And in this case, and many of you may be familiar with this just in passing because it's now routine paperwork, but the I-9, the documenting the citizenship of an individual, became part of the way human resources does business. It created a lot of confusion, a lot of upheaval back in 1986, 1987 when it was being implemented, because there's this quirky twist that you cannot ask for proof of citizenship before offer of hire. Okay, think about that. So you can ask a person, you can ask on a job application, are you a citizen of the United States? Check the box, yes or no. But you can't verify that unless and until you've actually made an offer of employment. So tell me why when we meet next Thursday night. Tell me, why is that? Why would that be so? Why could you not ask until after the offer of employment? But now you're chasing down. Oh, and I believe it stipulated too that it had to be received and documented. I believe it was 3 days after employment. So congratulations on the job. You need to bring in a birth certificate and or two other forms of identification to complete your I-9 citizenship form. And you've got to do that in the next 72 hours. And then the person doesn't show up. So we ended up just having to chase people down, finding ways to facilitate this process so we wouldn't have people falling through the cracks. Because if we ever were audited and we didn't have the documentation, the city, any business or industry could face fines for not having the documented citizenship of its employees. So Teresa and Hidea, we're going to talk more about that. And occupational safety and health, Danny and Devin. So OSHA, Occupational Safety and Health Administration, has, and there's a link here, you can open the link. It is volumes and volumes long of safety regulations, section after section, addressing almost any safety concern that you could see, that you can find in the workplace, and a catch-all. And the catch-all is the general safety clause, which simply says that an employer must provide a safe and healthy environment for its employees. So if there's something missing, if there's a very specific item that's missing, it fits in the general clause. Okay. There are general industry OSHA regulations. There are construction regulations. And then, as I've suggested a couple of times, I think that states have peeled off. So New York State being New York State, California being California, basically created their own power, their own authority over public employee safety and health. So in New York State we have PESH, which almost is parallel. So OSHA is run under the auspices of the Department of Labor. In New York State, PESH is run under the auspices of the New York State Department of Labor. And I will share with you some of my experiences in dealing with the local Department of Labor when situations came up in city government. Actually, a very constructive working relationship can be entered into. So as we begin to draw down on my list of essential HR law, we come to the Family and Medical Leave Act 1993. You see they're introduced in 1985, passed 1991, signed into law in 1993, just as an example of sometimes the things that just seem so worthy and that make so much sense can take so long. Although I guess when you think of some of the other roadblocks that we've experienced along the way, maybe 8 years is not really an unreasonable thing. So, but at its inception, 12 weeks of unpaid leave to any employee with a medical condition for themselves or immediate family, or adoption or birth of a child, for business and industries of 50 or more employees. In 2009, through executive order, we had added to this 26 weeks of unpaid leave to injured or ill military service members, and 12 weeks if for a son, daughter, or spouse. And then, another executive order, 13706, that federal contractors must supply their employees with up to 7 days of paid sick leave annually. So there's that, again, there's that scope of executive authority applying to contractors. And here's the sad news. This is where the United States is on paid maternity leave. Literally at the bottom rung of the ladder. I mean, my goodness, right? Pakistan, South Africa, Mexico, and there's the true north. There's Canada with 50 weeks of paid leave. And so we still struggle through this. We do, as I suggested earlier, we have business and industry acting on its own. We have states acting on their own to correct this in the absence of federal leadership. So we are about halfway through our lesson, and I'm going to kind of take a break, and maybe we'll take a break at this point when we meet on that Thursday night, because we're going to pick up and discuss job analysis and job audit in part 2 of the lesson.